Welcome everyone to our webinar on the GDPR, ensuring your business is compliant. My name's Lauren and I'm a Senior Associate in LegalVision's Commercial and Privacy team. And today I'm joined by my colleague Olivia, one of our associates in our Commercial and Privacy team. Before we begin, I've got a couple of quick housekeeping items to go through. So firstly, at the end of the webinar, you'll receive an email with a recording of today's webinar. There's also going to be a question box or a chat box where you can submit any questions that you've got. We'll go through them at the end, so we certainly encourage you to send through any questions that you've got. And at the end of the webinar, we're also going to send through a short feedback survey, and if you could fill that in, that would be really helpful for us. The other thing I'd like to mention is that all attendees today are eligible to receive a free consultation with us to discuss how we can help you with your privacy compliance and any of your other legal needs. To request your free consultation, you'll just need to provide your contact details in the survey that appears at the end of the webinar. What I'll do now is I'll quickly run through what we're going to be discussing today, and then we'll get stuck into it. So the first thing we're going to run through is what your responsibilities are under the GDPR. We'll then get into what privacy documents you need to have in place. We'll run through the rights that individuals have under the GDPR, and then we're going to talk through some interesting points on using direct marketing and cookies to, I guess, expand your business, and then we'll run through some compliance tips at the end. As I mentioned before, we'll answer your questions at the end of today's webinar, so please feel free to send them through as we go along. So first of all, I'll hand over to Olivia to speak about understanding your responsibilities under the GDPR.
Thanks, Lauren. So the GDPR is a regulation which governs the processing, movement and protection of personal data of individuals. I'm sure you've all heard of it before. It is known for being some of the toughest privacy laws in the world. So the GDPR was first introduced in the EU, and following Brexit, the UK retained the GDPR as domestic law. So in our presentation today, when we refer to the GDPR, we're referring to the UK GDPR. The purpose of the GDPR is to protect the rights of individuals when businesses are handling individuals' personal data. So the key principles of the GDPR are set out in this slide here, and the laws are designed to ensure that businesses handle personal data in this way. So, for example, ensuring personal data is used only where necessary and only kept for as long as necessary. For things like sensitive information, so things like someone's race, ethnic background, religious beliefs, health, or genetics, there are additional obligations set out in the GDPR. So you should just be aware of this if you are collecting that type of sensitive information. Under the GDPR, there are concepts of controllers and processors. So the obligations of a business under the GDPR will be different based on whether that business is acting as a controller or a processor, or both. So it's important to understand if you're acting as, when you're acting as a controller, when you're acting as a processor, because that could happen in certain situations. A controller determines what personal data to collect and how to process that personal data. So your business, for example, would be considered a controller if you decide that you must collect contact and payment details from your customers so that you can provide your goods or services. So, for example, LegalVision as a law firm is acting as a controller when it collects the names and contact details of clients to sign them up as a new client. A processor, on the other hand, processes personal data on behalf of a controller and does not determine how to process that personal data. So, for example, many B2B SaaS businesses, such as MailChimp, Stripe, and Xero, are considered processors when they're instructed by their clients to process personal data in a particular way. So, for example, if you put all of your customer data into a CRM like HubSpot, HubSpot should only be using that personal data to provide the CRM services. They shouldn't be using it to contact all of your customers to try and sell them HubSpot, for example. There are a number of obligations of both a controller and a processor under the GDPR, but we're going to talk about some of those key ones here today. So firstly, the key obligations of a controller. Firstly, a key thing is to identify a legal basis for processing each piece of personal data you collect and process. You need to have a legal basis in order to collect and process personal data, and it's a controller's job to identify what that legal basis is. need to have a privacy policy in place, and that should be kept on, a place such as your website, somewhere easily accessible for clients. And it's also a controller's responsibility to pay an annual data protection fee to the UK Information Commissioner's Office, which is also known as the ICO. Key obligations of a processor. Some of those are to only process personal data on the instructions of the controller. So essentially only to use it for the purposes that the controller has said that you can use it for. To obtain the consent from the controller to engage sub-processors, so sub-processors being, those businesses that help you operate your business. And notify the controller of any personal data breaches. So if you're aware of any personal data breaches that would affect the controller's personal data they've given you, you need to be telling them about that as well. There are some shared obligations as well from both a controller and a processor. So some of those are to implement security measures to protect personal data, to put in place a data processing agreement between the controller and the processor, and a processor and a sub-processor, and that needs to set out how the personal data can be used, and there's all sorts of other mandated information that needs to be in that data processing agreement. And to appoint a data protection officer or a EU or UK representative, depending on the size of the business and where it's located. So I'm going to hand over to Lauren now to talk a little bit more detail about privacy-related documents.
Thank you, Olivia. So I suppose as part of that and as part of the requirements under the GDPR for both controllers and processors, there's a number of key documents that your business should have in place, and I'll run through them right now. So the first one I'm sure you've heard of is a privacy policy. And this is a document that's required by the GDPR and that you need to have. So a privacy policy or a privacy notice is a document that tells individuals how you handle their personal data. The GDPR sets out specifically what needs to be included in your privacy policy. So that includes things like what sort of personal data you collect, who you share it with, why you're collecting it, and what you do with it. You also need to include a few other things like what the rights of individuals are in connection with the GDPR and how they can make a complaint. So it's important that your privacy policy does reflect all of those mandatory requirements that are set out in the GDPR. Typically, your privacy policy should be freely available. So as Olivia mentioned, for example, you might set it out on your website. And every time you're collecting personal data from an individual, so whether that's on a contact us form or whether that's someone signing up to your services, you should let them know that you handle their personal data in accordance with your privacy policy. So that might be as simple as just having one line underneath the sign up form saying, we handle your personal data in accordance with our privacy policy, and then having a hyperlink to it. You'll also need to have an employee privacy notice if you've got employees in your business. This is very similar to a customer-facing privacy policy, and it's the same requirements of what needs to be in it. It's just that it will be directed towards your employees, and often you'll find this in an employee handbook. The next document I'll touch on, Olivia briefly touched on it just then, is a data processing agreement. So this is a document that's required when a data processor is being appointed by a data controller or by another data processor to process personal data. And so it needs to be used in every situation where a data processor is being appointed. So a classic example would be if you are engaging a SaaS provider as a processor, or perhaps you are the SaaS provider, you would have a data processing agreement in place. And if you are a data processor, it's often a good idea to have your own DPA or data processing agreement so that you can have all of your customers on the same DPA and you're not having to enter into a new one each time. If you're a data controller, you're going to be a bit hard pressed to try offer up your data processing agreement to Google. You're probably going to have to accept theirs. There are just a couple more documents that I'm going to run through that your business should have in place. So these will be on the following slides. So the first is an international data transfer agreement. Now, previously under the GDPR before Brexit, these would have been known as the standard contractual clauses. But in recent times, the Information Commissioner's Office has handed down what's called an IDTA, or an International Data Transfer Agreement. Essentially, if you're sending personal data overseas to countries which are not classified as having adequate data protection laws, you will need additional standard or additional clauses in your contracts with them if you're not relying on some other sort of exceptions such as consent. And so there's some standard documents that's been handed down by the ICO, which we can incorporate into your data processing agreement. And so you should be using them if you're sending personal data overseas. And then the last two things I just want to touch on are your internal documents. So we recommend having internal privacy registers. There's a lot of recording and reporting requirements with the GDPR. So you should be logging all decisions your business makes with respect to privacy decisions. So for example, if you are choosing what lawful bases to rely on when processing data, there should be a record of that somewhere. If you get any requests from your clients, any data subject access requests, there should be a log of that. If there's any data breaches, we should be logging all of that and keeping it in an accessible location. And then lastly, it's useful to have internal policies in place of what to do in the event of certain situations arising. So for example, if there's a data breach, it's useful to have a data breach response plan so that you can respond correctly and quickly, noting that generally you've got a 72-hour time frame in which to respond. And also it's useful to have a data retention policy. So this would set out which documents you keep and for how long you're going to keep them. Moving on, I'm going to get Olivia now to have a chat about the rights that individuals have under the GDPR, and these are some of the requests you might receive when running your business.
Thanks, Lauren. So yes, as Lauren mentioned, data subjects, so people like your customers, contractors, employees, have rights under the GDPR. And it's important that you know what these are so that if you receive any requests from these individuals, you can lawfully respond. So some of the key rights the data subjects will have under the GDPR are things like a right of access, so a right to access the personal data that you hold about them. So for example, a customer might make a request to ask you to see what personal data you hold about them. A right of rectification, so a right to update, right to request that personal data that you hold about them is updated. A right to erasure and a right to be forgotten. So that's something that's really unique to GDPR. And it's a right to have the personal data you process about the data subject erased in certain specific situations. So for example, a lead or a former customer of yours might contact you and ask that the data you hold about them is deleted. The right to object or to restrict processing, the right to automated individual decision making, including profiling. So a right for an individual not to be subject to a decision that's made that is based solely on automated processing. And the right to data portability. So a right to have the personal data sent to another controller. So for example, a customer might ask you to send the data you hold about them to a new supplier. You should ensure that your customer service team are aware of what they need to do when they receive a request under the GDPR. So often that will come through your contact us form or emails. Don't ignore the email or delay preparing a response, as you might find that you miss important deadlines. So it's really important to know that often, there's time frames such as sort of an obligation to respond within 30 days. So we generally recommend that you seek the advice of a lawyer to respond to these requests so that you make sure that you're sort of responding adequately and within the required timeframes. A lawyer or a sort of privacy expert can also help you understand what personal data you do need to send or erase, or whether there are circumstances meaning you actually don't need to comply with the customer's request. You should also note that you can't charge the individual to a fee to respond to their request unless their request is manifestly unfounded or excessive. So what that means is, if they've made repetitive requests for the same information, perhaps you can charge them for that request, but otherwise note that you can't. So changing tact a little bit, I'm going to pass back to Lauren now to talk a little bit about leveraging marketing and cookies and complying with the GDPR.
Thank you, Olivia. Yes, this is a good one to touch on. It's something that we get asked about every day, really. Today, most businesses are using direct marketing and using cookies to ensure that they can grow their business, increase sales. It's basically an essential way of growing your business these days. So there are laws that sit alongside the GDPR called the Privacy and Electronic Communications Regulations, and these are the laws that govern direct marketing and use of cookies. So firstly, I'm going to touch on email marketing, which is very similar to text message marketing as well. So essentially, if someone requests that you send them marketing materials, so that would be considered solicited marketing, and there's no restrictions on that. But generally, if someone's not made that specific request, you're going to need to rely on consent to send them email marketing, unless there is an exception that applies. Now, in terms of getting consent, an individual must have a genuine understanding of what it is that they're consenting to when giving that consent. So you need to be clear on what it is they're consenting to. The consent that they make should be granular. So what that means is that if you are trying to send them both SMS marketing as well as email marketing, you get consent in different levels for both of them. And generally, for consent to be valid, a positive action must be taken for the consent to be valid. So for example, they would check a text box or click on a slider, for example. So the clearest way to obtain consent is usually to invite an individual to tick an opt-in box, confirming that they wish to receive marketing messages via a specific channel, so such as the SMS or email, phone call, etc. There is a key exception to gaining consent, and that is called the soft opt-in. So this applies where you've got either existing customers or someone that's entered into negotiations for sale with you. So for example, they've called you up, they've asked for a quote. So if you've obtained someone's personal details in that manner, you can send them marketing materials, provided it's similar to what they purchased from you or for what they inquired about, provided you give them an opt-out option at the time that you collect their personal data. So for example, if someone's checking out of your e-commerce page, what you'd need to do is have a box which says, I don't want to receive email marketing, as opposed to an opt-in box. You also need to provide this option in every communication with them thereafter, so an unsubscribe button in your emails you send. Alongside that unsubscribe button, you should make it clear in all of your emails who you are, and then make it super easy for individuals to opt out. The last thing I'll just note on this is that these rules don't apply to what we call corporate subscribers. So they are businesses. So the thing to note there is that although they don't apply to corporate subscribers, so that's a limited company, they do apply if you are dealing with sole traders, so just individuals running their own business. I'm now going to move on to quickly chatting about cookies. So it's a little bit different here, but cookies are text files that can be placed on an individual's device to store an individual's preferences. They're used by many, many websites, and they can do a number of things, such as remembering what your preferences are, recording what you've put in your shopping basket, counting the number of people on your website. They can also definitely be used for advertising, and that's one of the reasons why when I go onto my Instagram account, I see ads for things I've just Googled. That's all through the use of cookies. Now, when you use cookies, you must tell individuals that you're using cookies, explain what the cookies are doing, and then get the individual's consent for each type of cookie that you're installing on their device. So this is the reason why on many websites you see pop-ups that come up explaining what cookies are being used and giving you the option to say yes or no. Now, there are many pop-ups that come up. Some are compliant, some are definitely less compliant. So in order to be compliant, the consent, as I mentioned before, must be freely given. So individuals must have a choice to say yes or no. And if they say no, they should still be able to go onto your website. It should be informed. So you should tell them what sort of cookies you're using and what they do. And it needs to involve some sort of positive action. So that would be actually clicking yes, I agree, or a checkbox or a slider. So you can't just get consent by having some sort of message at the bottom of your screen which says, by browsing this website, you agree to our cookies. You also shouldn't be pre-ticking checkboxes or pre-filling any sort of sliders. So as part of your cookie pop-up, we recommend you also have a cookie policy which sets out in more detail the types of cookies that you're using using and what they do. And it also should provide users with a way to change their preferences. So if I click I agree today, in 2 days' time, if I've changed my mind, I should be able to do that. That's sort of the last thing I'm going to mention on cookies, but if you do have any questions, definitely put them in the chat box and I'll run through them at the end. But for now, Olivia's going to run through some practical tips for ongoing compliance with the GDPR.
Perfect, thanks, Lauren. So hopefully you've picked up a few little practical tips along the way, but thought we'd sort of summarize these here. So first things first, you've got your privacy and policy in place. It is a living document, so ensuring that you update your privacy policy every year or sooner if the types of personal data you collect changes or is used differently. Review the contracts with your existing suppliers and confirm that it covers the transfer of personal data. So look at your existing contracts with suppliers. Does it cover what they're going to do with personal data? And then obviously with any new supplier contracts that you're going to be using, make sure these are reviewed before you sign them. Obviously for sort of general contractual terms, and then also to ensure that the privacy obligations of that supplier are adequately covered in the contract. Have some internal documents prepared to allow you to efficiently respond to situations or data subject requests. So for example, if you think there might be a data breach, if you've already got a data breach response plan in place, it's going to make it nice and easy for you to be able to respond quickly and efficiently to that data breach. And a data subject request plan. So, the types of data subject requests that we talked about before, such as, someone contacting you and asking to access or erase their personal data. If you've got a bit of a plan of how you'll respond to those requests, again, that will make sure that, everything's quite streamlined and that everyone in the business knows what they need to do if those requests come about. Undertake training with your staff to ensure that they're aware of your GDPR obligations. So obviously customer service team, customer facing team should be aware of any queries that come through website or phone in relation to privacy. And obviously privacy should be a big part of the business and its decision making. So ensuring obviously that the business and the staff are aware of privacy when making key decisions. Monitoring for data breaches, that falls into sort of the technical aspect of the business. Things like making sure that you're sort of keeping in touch with your software team in relation to potential data breaches, but also things like an employee sending an email to the wrong email address can be a data breach. So it's really sort of a whole team effort to ensure that you're monitoring and aware of data breaches and what they could be so that you can respond accordingly. Undertaking a data protection impact assessment. So this is important and required if you're processing a high volume of personal data or sensitive types of personal data. So some of the things we mentioned before, health data, someone's race, genetic information, that's all going to need to be subject to things like a data protection impact assessment to make sure that the impact on the individual is relative to what is required. So review the information that you collect from customers and confirm that you have a lawful basis to process this. So that's, assessing all the personal data you collect from customers. Is it required and do you have a lawful basis? So just doing a bit of an internal stock take there. Look at the requirements of whether you need a data protection officer. So if you're a larger business, that could come about, or if you've got a presence in the European Union, whether you need a European Union representative. If you're a controller, pay your annual ICO fee. It's a really easy way to show your customers that you're committed to personal, to the GDPR and personal data protection. And obviously it's a requirement of the GDPR as well. And this comes back to sort of looking at your customer data and what you're collecting, but only collect what you need from customers and individuals, and make sure consent and privacy awareness is just really built into your customer service process. So aside from those practical tips, I guess it's important to know sort of, what the penalties are for non-compliance. So the ICO, the Information Commissioner's Office, is allowed to penalise companies with fines of up to 4% of annual global turnover, or up to £17.5 million, whichever is the greater for non-compliance with the GDPR. obviously huge fines there. So really important to ensure that you're compliant. Aside from those costs, data subjects themselves also have the right to seek compensation or for damage suffered as a result of infringement of the GDPR from either the controller or the processor. So, both of those businesses can be, responsible there for costs to the individual. So really important to comply and ensure that you've got everything in place. I'll hand back over to Lauren now to chat through the final comments and also to answer your questions.
Thank you, Olivia. So that concludes the main part of our webinar today. You might find our GDPR Essentials fact sheet useful. You can locate it in the handout panel or by scanning the QR code on the screen right now. We also have an upcoming event that may be of interest to you on playing it safe, mitigating your business health and safety legal risks. This will be on Tuesday, the 15th of August at 10 a.m. and you'll be able to register through our website using the link on your current screen. As Olivia mentioned, we're going to answer any questions you've got shortly, so please feel free to submit them right now. And while you're submitting them, I'll just take a minute to tell you a bit more about LegalVision's membership. So LegalVision's membership is a cost-effective alternative to the expensive hourly rates you may experience with other law firms. For an affordable monthly fee, what you'll receive is cost certainty and all-inclusive legal services. And this includes unlimited document review, drafting and amendments of business contracts and commercial leases, unlimited advice consultations. So this will be with our team of specialist lawyers, including business structuring, employment, disputes and more, and as well as unlimited domestic trademark registrations. So as a LegalVision member, you won't need to worry about the cost of lawyers ever again. Think of it as having your own legal counsel. We'll take care of all the business as usual legal work and you can focus on running your business. And if you are an in-house legal counsel, our membership is a cost-effective solution for outsourcing additional work. To learn more about how our membership can help you, you can request a free consultation when the survey appears at the end of this webinar. So now what we'll do is we'll run through some of the questions that have come through, and if there's any more, please feel free to submit them. So the first question that has come through is around DPAs. So I am using HubSpot. How do I get them to sign a DPA? Olivia, do you want to take this one?
Perfect. So I think Lauren touched on it earlier, sort of when it comes to larger processes, such as HubSpot, other SaaS businesses, they have their precedents in place or their standard data processing agreements. So you're not going to be able to draft one and sort of give it to them to sign unless you're a very, very large company. The best way to find, a SaaS businesses or, a sort of large processes data processing agreement is just by going onto their website. So unless they already give it to you as part of sort of the contract signing process when you're joining up, what you may find, they may not do that. So what you can do is you can find it on their website, usually by going to the legal section. What you can usually do is find that they've got a data processing agreement on their webpage, which is already pre-signed by them. So obviously you won't be able to sort of amend it or change it, but should be compliant with GDPR. Obviously, get it reviewed, but you can find their data processing agreement there and sign it on your end and ensure that it's executed. So that's probably going to be the easiest way to get a DPA signed by HubSpot or another sort of large processor. Looks like there's another question. So, sorry, Lauren.
Yeah, I was just going to say some questions have come through around how is it best to decide who is the data processor and data controller. So I guess the first thing to do is think about all the personal data that your business comes across and how you come across that. So have you come across it because you've directly asked people for it? Or are you coming across it because you're receiving it from somewhere else and someone's asking you to perhaps help them with that? So a lot of businesses will be controllers in some respects. Definitely whenever they're signing up any customers, you're choosing what sort of information you're going to be handling there. I guess it becomes a bit more complicated if you're working with other businesses. So for example, if you are a consultant and your clients are handing you personal data about other businesses, that's a time when you might need to think, okay, well, where have I got this personal data from, and am I only processing it on behalf of someone else and they're telling me what to do with it, and then I can make, my reports, etc. I suppose the other thing to think about is that it is a bit more complex than just a controller and processor relationship. We also have the concept of joint controllers. So that's when two businesses jointly determine what personal data they're going to collect and how they're going to process that. This is obviously a lot less common, but it can come up in circumstances. For example, if you've got two companies perhaps launching a co-branded product together and organising some sort of marketing event together to launch the product. In that situation, they might be considered joint controllers. And the other thing to think about is sometimes we can have processors and sub-processors. So you might be a processor. So for example, you're some sort of SaaS business, you've got customers inputting personal data into your system, but then you're using another business to help you process that data. For example, AWS or some sort of web host provider, then they will be your sub-processor. So there doesn't always need to be between two businesses a controller. Hopefully that answers your question, but if you've got something more specific to ask, let me know. There is another question here about email marketing. Someone has applied for a job with me. Can I send them marketing materials? Olivia, do you want to answer that one?
Yeah, definitely. So the answer is no. So unless you sort of receive consent for the use of, to sort of, they've explicitly agreed to receive marketing materials. That's obviously not the purpose for which they got in touch and provide their personal data. The personal data was provided in the context of applying for a job. So ultimately, the key thing to take away there is, only use the personal data for the purpose for which they got in touch with you, and in relation to using it for marketing materials, ensure they've got consent before you, use marketing. Before you use their personal data for the purposes of marketing. As sort of Lauren touched on before, there's the concept of the soft opt-in, but obviously that wouldn't be applicable in the situation where they've, provided their personal data for the, for a job application, for example. So yeah, hopefully that answers your question there. I think there was another one. Lauren, I'll pass this to you, but the question is, could you please explain whether controllers need to respond to customer requests for information erasure or production where the information has been disaggregated so it's no longer traceable to its source?
Yes, that is a good question there. I'll do my best to answer this, but if there's sort of more specific questions that you've got, then feel free to book in a consultation at the end of the call and we can go through it with you in more detail. Essentially, under the GDPR, individuals do have this right to erasure or this right to be forgotten. It's only in some situations that they have this right. So, for example, they only have this right if the personal data is no longer necessary for the purpose it was collected. So I think a key thing there is, for example, if you've got customers and they're asking you to delete some of their data, some of it you might not be able to delete. One, if you're going to continue providing services to them, but two, if you need to have a record that they were actually your client. So typically there's this 6-year statute of limitations period where they might make some sort of request or sue you during that period of time, and it's useful for you to have that information that they were actually your client. So there are situations where you do need to keep that information, so you need to run an assessment at the time. Now, in relation to information that's been disaggregated, so it's no longer traceable, that's quite an interesting question. So typically, if you've got a data set where you can't trace it to its source, it would not be considered personal data. Now, this is obviously a bit of a subjective question, maybe not subjective, but it depends how you've deaggregated the data. And so if, for example, we've got a data set where perhaps in an office, there's 20 people and there's 1 male and 19 females, and you asked a a couple of questions. One of them was their gender, and then the other, you asked some other questions which relate to perhaps health information. Now, just because you've removed all the names, because there's only one male in the room and you've got that data there, then we can trace who answered the other questions. And so in that sense, it would still be considered personal data because we can identify who it is. So if you've anonymized data in a way where you can't trace who it is, then no, we don't necessarily need to delete that data set. But if we can trace who it is, then that would fall under that right, and we need to do an assessment of whether or not you can keep it or whether it needs to be deleted. There is another question here. Can I check my understanding that personal data covers work email addresses if it identifies an individual person? Olivia, did you want to run through this one?
Yeah, absolutely. So the answer would be yes. So if a email address, has, for example, someone's name or last name as part of, their work email address, it obviously would contain things such as their name and also where they work. And it might sort of tell you, well, I doubt it would be in their email address what their job is, but perhaps it might be. So, there's already personal data there related to perhaps their name, what their position is, and where they work. So yes, in that sense, it would certainly be personal data when dealing with a work email address. Yeah.
But if there's a follow-on question from that, which I presume there might be, definitely feel free to book in a consultation after the webinar and we can go through that in more detail. Are there any more questions there, Olivia? I think there's one more.
Oh, sorry, yep.
Do I need to get consent to use Google Analytics and Google Ads? This is certainly a question that comes up quite regularly. So in short, yes, Google Analytics uses cookies and so do Google Ads. And so generally you need to get consent to use those. There's certainly been a lot of cases where I've had lots of clients which have received emails from Google saying they're going to cut off their services if they don't get consent. So certainly something that you need to have in place, yes. I think that might be all the questions for today. So we'll wrap up now. After the webinar, a survey will pop up and we would really appreciate it if you could complete the survey. It'll take just 30 seconds. Please include your contact details to receive a complimentary legal consultation to discuss how we can help you with ensuring your business is compliant with GDPR regulations. Thank you so much for joining us and hopefully we'll hear from you soon.